Well, welcome. Good afternoon. We're going to be discussing a topic that is rather obvious but not done very often, and that's a concept called understanding your trust. A novel concept, right? We want to address the idea that many people get these wonderful, expansive, detailed, revocable living trusts. They put them on a shelf, they collect dust, and the clients don't even know what they have. They don't understand the terms. They don't know where to find the terms. You ask them questions about their trust, and they have no clue. So as part of our education program, which we want to address for all our clients, all our families of the clients, we wanted to address understanding your trust. We don't want to overlook the fact that you may not be used to dealing with these things. And once you understand the nature and concept of a trust, it becomes a lot more clear, it makes a lot more sense, and we find clients and their families feel a lot better about things. So, my name is Doug Anderson. I am the owner and founder of Legacy Estate Planning. I have been doing law since 1982, but I've been doing estate planning specifically and only, exclusively, for the last 10 years. This is all we do, and so we get to know our genre pretty well. I go to conferences all the time, and so this is just something I love, I have a passion for, but I really have a passion for making sure my clients and their families understand how all this works. And so this is going to be a rather short educational clip, but I think it's going to be valuable and give you a nice overview of how this all works. Oh, and by the way, this is the second of what we call our Nuts and Bolts series. These are the foundational classes. Nuts and Bolts 1 is Successor Trustee Training. You may want to watch that video as well. This is Nuts and Bolts 2. So hopefully with that, you can come back and review these at any time. All right, let's start with the mechanics and the nuts and bolts of how a trust operates. We're going to be talking about basic trust concepts. We're going to be talking about how the trust operates. You as a client need to be refreshed on this because we walked you through that at the design meeting and at the signing meeting when we delivered all your documents to you. But you still often need refresher. And then for the family members who might be successor trustees or just beneficiaries, it's important for you to understand how this works as well. And then we want to talk about some specific provisions and where to find them in the document. So let's highlight a couple of specific topics in part 2. We're going to be talking about powers of appointment, what those are, and then trust protectors. A lot of people have never heard of either of those. So we're going to give you a little bit of introduction to them. We're not going to make you a lawyer, but at least you'll have a warm fuzzy as to what these mean, and you'll feel more comfortable with the process when you see them. So what is a trust and how does it work? The $64,000 question. This is something we could spend all day on. I'm just going to give you an overview, okay? I like to use the analogy of a treasure box because a treasure box contains the idea that having a trust is like owning things in a different manner. You own them wearing a different hat. Instead of you owning your assets as Doug Anderson individually, I own them as Doug Anderson, trustee of my revocable living trust. So I am named as the trustee. I am named as the sole beneficiary. I am the creator of the trust. I can terminate the trust. I don't have any standards as to getting access to my money. It's just the way things are now. I just wear a different hat of trustee. And if I do that, I have certain advantages. So, in terms of what a trust looks like, it's just a document. I have seen trusts range in size from as little as 3 or 4 pages to as long as hundreds of pages. Ours are kind of in between. So this portfolio, this 3-ring binder, what we call the red binder, is where we keep not only the trust for our clients, or the clients keep them themselves, but also all their other estate planning documents. So this will also include powers of attorney for finances, powers of attorney for medical care, living will, a pour-over will, all those different things. So we have them all in one binder, but right behind one of the tabs is the trust. So this is mine. This is about the size of the trust. So it's lengthy because we're dealing with a lot of circumstances that we don't know whether we're going to need or not. A lot of what you might call just-in-case provisions. What we call sweaters in a suitcase. So if you were to go to Arizona in the summer, where temperatures are typically 100 degrees, I bet you're still going to pack one sweater at least in your suitcase, just in case it gets cool in the evenings, right? So these are sweaters in a suitcase. A lot of these provisions are just-in-case provisions, belt and suspenders, whatever you want to call it, because we don't know what the future holds. So we have a lot of contingencies in here that we may never need, but they're in that trust. A trust is a legal entity. It's a container, like I said. It's like a treasure box. So I got this treasure box in Catalina Island. I had the pleasure of going there last year, and I found this. Looks like a little pirate's treasure box. So that's what I like to think about. And I like to imagine being on the beach, walking along, strolling, having a good time, enjoying the waves coming in, the sand, the sea breeze coming in, seeing the palm trees in the background, right? And in that blissful time, I come across a treasure box. Now, that would be a great day, would it not? That's an exciting time. It's not every day you come across a treasure box, right? And so, if I came across a treasure box and it looked like this, with a lid that was closed, I'm going to want to look at it, but I'm also going to want to do something. And that's, I'm going to want to open this up, right? Because if I open it up and I find that it's empty, it's not going to be so exciting then, right? Then it's just the value of what the container is, which isn't much. But if I open it up and there's a lot of bright, shiny objects in here, now I'm really going to be excited, because now that means things of value are in this treasure box. There is a treasure in the box. So with a trust, what we want to do is create the documents, create the container, the treasure box. But then what we want to do is make sure we retitle all our assets into the name of the treasure box or the trust. And by retitling the assets, they go in automatically. Now here's a little bit of a myth. A lot of people who get a trust seem to think that all they need is the documents, and everything just magically appears inside the trust, and you don't need to retitle anything. That is wrong. And so anyone who says that probably has a very empty treasure box. We make sure with all our clients we take 2 steps with this thing. It's not enough to just do step 1 of creating the treasure box or the documents. We need to also make sure it gets filled up with all the assets. We don't want a bunch of straggler assets outside the box that are unprotected, because only the assets in the box are protected assets. And there's a lot of different protections we can get with that trust, but we're not going to go into now, but the point is we need them in the trust. By the way, the trustee who is head of this trust, who has authority over this trust, only has authority over assets that are in the trust. So if we're going to create a trust, make sure it is fully funded, it is had the assets transferred in. That's what we mean by a treasure box fully funded. Okay? So that's the idea. It's just another way of holding your assets. It's like having a hat. You know, Doug Anderson individual, and then I take my hat off and I put Doug Anderson trustee of the Doug Anderson Living Trust. Now I have authority over all those assets in the treasure box. So it's a container. It's a separate legal entity of holding my stuff. It includes operating instructions. It's a contract in and of itself. It goes into effect when we sign the document, not when we die. So a will goes into effect when? When we die, right? So we can't do any mental disability planning with a will, except maybe with the use of a power of attorney. Powers of attorney are pretty limited. All they do is give power and authority, but no guidance and direction. This is a contract going into effect when we sign it. So we can give planning and guidance and direction for mental disability planning in this. Just one example of all the advantages of this going to effect when we sign it and being a contract. Because it's a contract, we don't need court permission. A will is a wish document. It needs to be court approved. The judge has to agree, has to accept the terms. You could name a guardian, for instance, of your children. And conceivably, the two sets of parents could say, no, since they wrote that agreement up, those parents that they cited to be the follow-up guardian, they're bad people. You know, they're druggies, they're gamblers, whatever it might be. And then same thing with the other side of the family. So you could have the two sides of the family fighting. The court has to decide, because a will is not a contract, it's a wish document. In a trust, it's a contract. So you could name the guardian, and that is it. That is the person it's going to be. So it helps to avoid litigation, it helps to reduce the risks of litigation, and it sets everything in order a lot more clearly because it's a contract. As I said, it controls every asset that's placed into it, but it doesn't control assets that are left outside of it. That always has to be considered, making sure our treasure box is full. And again, you don't have to have court permission. And the court doesn't keep a copy of the trust. It's all privately done. Another advantage of a trust, by the way, over a will. A trust is private. So they're not going to know what your assets are or who are going to get them. And so, again, private contract goes into effect when we sign it, not when we die. Legal entity all itself. But if we don't take that second step of putting assets in there, it's a waste of time, it's a waste of money. And quite frankly, candidly, most trusts out there are empty trusts. They're empty treasure boxes, or very partially filled ones. Estate planning attorneys have a tendency to just help their clients with the deeds, the real estate, because that's a legal document. But when it comes to getting the cash accounts in, the investment accounts in, the annuities, the retirement accounts, the life insurance, all the other assets, that's left up to the client, and the client typically doesn't do that. In our system, we stay with the clients to make sure all that is done, and we follow up. So hopefully that's not an issue, but we always have to be aware of that, and that's the concept, that's the idea. A trust provides for a pre-planned mental disability structure. When we talk about disability, we're not talking about physical disability, because you can still make decisions if you've got a broken leg or a broken arm. We're talking about mental disability, where you can no longer make decisions on your own. You have to act through an agent. In the case of a trust, that agent is called a trustee or a successor trustee. So we can do mental disability planning. Again, we set this up privately. It's a contract. We set up a trusted agent to act and pay our bills for us if something happens. And then that avoids that court intervention. We don't need the court to intervene. The trust provides a pre-planned distribution process. So not only does it set up a container for us to use and have full access to whenever we want those assets, but then if something happens to us, either mental disability, we provide an agent with instructions, or we pass away, we can have a distribution scheme. What happens to these assets in the treasure box after I'm gone? We have a plan. We have a plan A. We have a plan B. And even we have a plan C. We always have successors. So a lot of times people will say, well, after my spouse gets everything, I want my children to get it. What they often don't think is, what happens if one of your children predeceases? We need a plan C. The spouse was plan A, the children plan B. What happens if a child predeceases? We don't always die in the order of age. And we have to make sure we're aware of that. And so we have to have a distribution scheme that is providing for contingencies in those situations. By doing that, we again avoid court intervention. We don't have to go through probate. If everything is in the trust, if everything is in the treasure box, then we, for probate purposes, do not own the assets. Things that are probated, at least in Virginia, are anything that is in our own name. So if we set something up where we're married and we're jointly on all the assets with right of survivorship, then when I die, it's going to automatically go to my wife, right? No probate necessary. But what about my wife when she dies? Now it's in her name only, and it's going to go through probate. So anything that's in our own name only will go through probate. But if it's in the trust, it's not in our name, is it? So it's not going to go through probate. So not only with a trust can we reduce the risk of probate, we can guarantee no probate. But remember, we can only guarantee no probate if we put all the assets in. I'm harping on this because it is a significant reason why most trust planning does not work. It didn't work because we didn't get all the assets in that trust or treasure box. We left straggler assets behind that had to also go through probate. So as long as it's in a trust, no probate, guaranteed. And that's one of the reasons why a lot of people use trusts. All right, it also can provide for asset protection. Not for you, but for your loved ones after you're gone. And I'll go into this in a moment of how that works. We use the school bus story. So with the school bus, it always starts with the fact that, remember, we cannot protect our own assets that are in our own revocable living trust. The reason is because we are our own trustee, we're our own beneficiary. There's no standards for us getting money out of the trust. We can get it out for any reason. Well, if that's the case, so can our judgment creditors, right? But when we pass away, that revocable living trust becomes irrevocable, right? And if we keep things in trust for our loved ones after we're gone, we could get asset protection. So here's how it works. Let me give you a story. And we're big on stories because we think stories are a good way to learn legal concepts. So let's say I wanted all my property when I pass away to go to my wife, and then when she predeceases to go to our children, right? Not a very unusual plan, pretty standard. So I passed away. Let's say I had a will. And after I passed away, my wife is running to a meeting. She's late. The streets are wet. It's raining. It's slippery out there. Traffic is crazy. People drive crazy, especially in Northern Virginia where we are. Traffic is it's a minor miracle we get anywhere on destinations on good weather days, let alone bad weather days. So on this bad weather day, my wife is driving too fast, slams into the side of a car, killing a whole family of people, right? Not likely to happen to any one of us, but it happens to somebody out there all the time. And when that happens, it's catastrophic. Would you not agree? So here's what's going to happen. Remember, my wife was driving too fast. So she's going to be sued. The family and survivors of that family who passed away are not going to be happy. It's a litigious society. They're going to sue my wife. She's going to lose that lawsuit because she was driving too fast. She will be found at fault. The judgment is not going to be paltry. The judgment is going to be immense. It's going to be a catastrophic judgment. It's going to be way beyond the $1 million per incident that of the standard auto policy. It's going to be way beyond a $3 to $5 million umbrella liability policy. It's going to be way beyond that $4 to $5 million that we can insure. It could conceivably easily be in the hundreds of millions of dollars per person. I have seen judgments of 150 or more per person, wrongful death. So if it's a whole family, that could be really catastrophic. 150 is bad enough. Well, here's the problem. I did not have anywhere near $150 million as an inheritance to my wife to pay that judgment. Problem number two, anything in her name only is going to be gobbled up by that judgment creditor with the judgment of 150, let's say, $1 million. The $5 or $6 million auto policy plus an umbrella policy covers a teeny drop of the 150 million. My wife is going to be in a hole for well over 130, 140 million dollars. She doesn't have that much money, so all her money would be wiped out. But here's the other problem. The inheritance that she received from me, if she receives it from me in her name only, is also going to be lost. So let's say I had a will. It all goes to my wife when I pass away. I tell my executor when I die, write a big fat check to my wife in her name only for my entire inheritance to her. So all her money and all the inheritance that's in her name would be wiped out and taken by the judgment creditor. My wife would be left destitute. Whatever the bankruptcy courts would leave her is all she has. That is not a plan that works for me. That is not something that I envisioned. I wanted that inheritance to last for her, to be a safety net for her. And then when she dies, to go to her kids and be a safety net for them. So that's what would happen if I had a will. What if I didn't even have a will? What if I just kind of did all my assets and put them in joint names because I wanted to avoid probate, right? So if I did it right, all our assets are in joint names. We avoided probate when I died, but now what happens to those assets? They automatically went to my wife. How? In her name only. So we have the same problem. The judgment creditors swoop down and take all my wife's money, and now they take all the inheritance that I intended her to have, and they take that as well. She's left destitute again. We're not making progress here. Let's say I had life insurance policies, or annuities with her being the beneficiary, or an IRA, she's the beneficiary. Anything with a beneficiary policy. Who am I naming as my primary beneficiary? My wife. So what happens when I die? The life insurance company cuts a big fat check to my wife in her name only. How much of that's going to be taken by the judgment creditors? All of it. We're not making progress here. What if she had a revocable living trust? But it was only one of those trusts that was designed to avoid probate. Because, as I told you, if we put everything in a trust, we guarantee no probate. On the first death, second death, even a common accident, right? So we avoided probate. That's the good news. The bad news is the trustee in that type of trust is going to be instructed to cut a check to my wife in her name only for the full amount of the inheritance. So how much of that amount is going to be taken by the judgment creditors? All of it. We're not making progress. However, if we don't give the money to our loved one with a big fat check, but instead we give it to them in trust. And remember, my trust went, when I died, from revocable and unprotected to irrevocable and protected. So if the money stays in that protected, irrevocable trust after I die, her money in that scenario would be wiped out, right? Her trust money would be wiped out because we can't protect our own assets in our own trust. But she wouldn't be left destitute. She would be able to live on my inheritance, my safety net, the trust money that I left for her in this irrevocable protected trust, if we set it up that way. So that's how we can get asset protection, not for ourselves, but for our loved ones after we're gone. And here's the great thing. After my wife dies, my trust says it then goes to my children in protected, irrevocable trusts. So if they hit the car, if they have a bad divorce, if they have catastrophic medical bills, it could be any number of things. We live in a litigious society. We could have a contractor working on the roof, they could break their neck falling off the roof. It doesn't matter what it is. Asset protection is provided if we keep it in trust after we die and give them that safety net that can last. So that's one of the concepts. The other idea with a trust that is helpful to families, if we keep it in trust and our loved ones are just using it as a safety net to take money out as they need it, but they have their own money to live on, to pay the bills, right? Well then, the money in that trust that's being kind of left alone is being invested, it's growing, and any financial advisor will tell you about the rule of 72. You divide interest rates and by the term of years, and it doesn't take a lot of interest rate to double your money in 9 or 10 years. Well, a spouse can easily outlive another spouse by 10, 15 years. That money that you left your loved one after you died has grown or can grow by twice as much or more than what it was valued at when you died. And then if you give it on to your children who will likely outlive you by 30, 40 years, imagine how much that asset is growing over the years. If it's just being taken out bits and pieces for their needs, you can give far more money than you had when you died to your loved ones by keeping it in trust. So you not only get asset protection to make sure they have the safety net, but you're actually able to give them a lot more money. It just grows. It's the magic of compounding. So we can take advantage of that. And of course, by keeping it in trust, we can protect against the spendthrift beneficiary. There is human nature that says that we tend to be pretty frugal or thrifty. We tend to be with our own money because we know how hard it was to earn it, right? You know, it just didn't grow on trees and we picked it off the tree. But when it comes to what I call frosting on the cake money, the inheritances, the gifts, the lottery winnings, those tend to be spent more freely, more quickly. In fact, the averages, there are a lot of statistics out there about the average inheritance, no matter how big, is spent within about 16 to 18 months. No matter how big, did you get that? Because it's frosting on the cake money. It wasn't in the balance. We weren't anticipating this, so that's ooh la la money. Let's have fun with this, you know. And so people know that, and so we can protect against that spendthrift tendency as we go along. So let's see how this looks schematically. So let's again start with a married couple. We have the survivor trust over here. So in my scenario, my wife had a trust, I had a trust. My wife's trust is revocable still, it's unprotected. My trust, which was revocable and unprotected, when I die, becomes irrevocable. And according to the terms of the contract, the trust, which is in the red binder, we do have to follow that, remember. We set up an administrative trust, which is a temporary holding cell, so to speak, container, where we pay the bills, get all that situated, and then after those bills are paid, we set up two sub-trusts, a family and a marital. These are designed, they're both irrevocable, they both have that protected status, and they both have access, this surviving spouse has access to both of those containers for her or his health, education, and maintenance. So we know what health is, we know what education is. You know, if my wife wanted to go to an interior design class or something, just take a couple classes. She can have the tuition and books paid for by my trust. She doesn't have to get a new degree, but if she chose to, she could do that and have it paid for by my trust. But what's maintenance? Maintenance is a very broad category that the IRS basically defines as our standard of living. So if we could have afforded, as we were alive and well, to go on a cruise, for instance, whether we chose to or not, my wife can take money out of my trust and go on a cruise. So if that's the case, she can buy a house, she can buy clothing, she can buy whatever she needs out of my trust because it's part of health, education, and maintenance. But all the rest of the money is left in there, protected. So we have these two sub-trusts set up for that. And then when she passes away, her trust and my two sub-trusts merge, and we set up for that asset protection purpose trusts that are protected and irrevocable for each of our kids. So they each have their own little fenced off sum of money, which is their safety net, so that if they hit that car, or if they have the bad divorce, whatever it might be, and their money might be wiped away, they won't be left destitute. They'll have our safety net to live on the rest of their days. That's a plan that works for me. And so a lot of our clients have plans similar to that. That's how it looks for a married situation. If it's single, they start then with their living trust that's unprotected, it's revocable, goes to that irrevocable protected trust, temporary holding container, the administrative trust, and then once the bills are paid, off into trust for each of the kids. That's again protected, has that asset protection, it's a safety net. That's how it looks. These things have to be set up, but that's how it looks, okay? So let's kind of go quickly then through how this trust is organized and how it's set up. It will differ a little bit between a married couple and a separate person, a single person trust, but I'll kind of try and highlight where those differences are, okay? So let's start with Article 1. And oh, by the way, I like to tell my clients that this is like a boat. Think of your estate or all your assets under your trust as a boat. I like that because the typical trust is just our name, the Doug Anderson Living Trust, or Whoopee, how boring is that? And that's the typical legal document, right? Why not have fun? Do you know that a trust can be named anything you want, as long as we name it, right? So let's have fun. You're going to get statements in the mail, monthly or quarterly, from all these financial institutions in the name of your trust. Why not have fun and name your trust something that means something to you? So I tell my clients, think of your trust as a boat. Because if you go to any marina in the country, you're going to see all these boats with these wonderful names. Some are pretty amusing, some are serious, some have meaning and impact, some are sentimental. Whatever it is, you can name this anything you want. So we've got some people who have some interest, and they've named some pretty crazy names, but they have fun with it and it works. So one of the things we can do, of course, is start with the name. So Article 1 will have our name, the name of the trust. It will also have, in Article 1, the fact that our trust number is, while we're alive and well, our Social Security number. We do not have to, we can use the Social Security number as long as we're alive and well. So when a bank asks for the number of your trust, it's the Social Security number. However, when we die, our Social Security number dies with us. So then we need to get an EIN number. But until that happens, we use the Social Security number. We file a 1040. We don't need to file a separate tax return, a 1041, for a trust until after someone dies, and we keep that trust in place. While we're alive and well, there is no 1041. We just do a 1040, use our Social Security number. Nothing really much changes. So that's all outlined in Article 1. Article 2 is the family. And this is going to be the same on both a married trust and a single trust. So with the family, this is typically where traditional planning, we name who our spouse is and who our children are, dates of birth. Okay? Now, again, whoopee-doo. I like to, again, have fun with my clients. We're pretty creative here, at least I like to think so. We're trying to think of other fun ways to do this that are legal, but you have fun with it. So this is an area, and anyone who gets to know me at all finds out pretty quickly that I'm pretty sentimental. I'm one of those criers. I cry at the weddings, I cry at the sad movies, I cry at happy movies. I'm just one of those guys. I confess to that. But what I like to do is, this is an area where if the family wants to, and we have this maintenance plan where we continue to work with the clients over the years, and we update their plan every 2 years. So this is a place in Article 2 where you can start describing each of your children, your hopes and dreams and aspirations for your children, how much you love them, how much they mean to you, how your life may have changed when they came into your life. All these things you can put in Article 2 of your trust, so that when you pass away and they're talking to the family about your trust, this can be read to the beneficiaries. And I guarantee you that will have power and impact. And it takes your estate plan to a whole nother level. We just transformed it from a boring legal document to something that has impact and power and will resonate with the beneficiaries the rest of their days. Because I guarantee you, they will forget what the inheritance was, but they'll hold on to those words that you spoke over them for the rest of their days. So you can actually speak a lot of encouraging words and things that you hope will happen to them, your dreams and aspirations for them, all that type of thing can be done in Article 2. Okay? Article 3 is something you can kind of ignore. It's needed, so it's boilerplate, they call it, but it's all about making sure we fund the trust and how that's done. Remember I talked about the treasure box. We need to not only create the treasure box with the documents, but we need to put your assets in the treasure box. That's called funding your trust. It merely means retitling the assets into the name of the trust. Okay? By the way, in Article 3 there are two other things I want to highlight. Tenancy by the entirety property. In Virginia we have what's called tenancy by the entirety property. It gives special protections for spouses. In Article 3, even if we change that tenancy by the entirety property into the name of the trust, it retains its protected status as tenancy by the entirety property. Secondly, community property. Virginia is a separate property state, at least as of today, and most states in the country are. But there are, and it's changing, there are 8 fully community property states. I think there's 2 or 3 more that are now having quasi-community property, maybe newly changed their laws to become community property states. California is one, Texas is one. So there are some community property states out there. Washington State is one. So you may have come from one of those states, so you have some community property. So in Article 3 we have provisions that retain the community property status because there's different rules that apply. So there's some things like that that are in Article 3. Article 4. This is one of the more important sections that you're going to want to know about. For this reason, it's got our mental disability planning, disability panel. In our planning, we take mental disability planning to the next level, I like to think. That's my statement, I'm sticking to it. Typical estate planning is if you don't have a plan, you're going to be found mentally incompetent, if at all, when one doctor says you're mentally incapacitated, right? Most other estate plans out there add another layer of protection with requiring a second concurring medical opinion. But still, that doesn't address the fact that the doctors don't really know you. There's a medical side to becoming mentally incapacitated, but with things like Alzheimer's and dementia, there's also a personal side. Because what they don't know is it's a gradual disease, they know that part, but they don't know you. So typically, in the morning, even with dementia or Alzheimer's, as you're in the early stages, you're fine in the morning. You can make your own decisions. You're lucid. There's nothing wrong with you. In the early afternoon, you may be starting to lose it, and then late afternoon and evening, you've lost it. Take away my checkbook. Don't let me near anything that might cause me to be spending money or being a little goofy, right? Well, who's going to know that? The doctors aren't going to know that. They don't know you. So I may have even had my doctor's appointment at 4 in the afternoon. I said some funny things. Doctor may have prematurely found me incapacitated. If we only have a doctor's opinion, that can happen. We want to maintain our independence and control as long as possible, right? Most people do. In fact, every single one of our clients has said that to me. So in order to do that, we need to add a family member or someone who knows us as part of the decision-making process as to when we might become mentally incapacitated. So with my trust, and a lot of people, they love this concept, we add a family member. So if I'm acting funny, my wife would take me to the doctor. Doctor number 1 says, Doug is incompetent. Okay. My wife takes me to the second doctor because my trust, my contract says I need a second concurring medical opinion. The second doctor agrees with the first. Okay, but it's not done yet. I am still able to write checks and conduct business because in my plan and in most of my clients' plans, there is another layer before I'm found incompetent. And that is that family member or someone who knows me. So in my case, it's my wife. So she's got to make an assessment independently of the doctors. So she can look at me the next day and say, the next morning, Doug is just fine. So I'm not going to find him incompetent just yet. The idea being, I don't want to be found incompetent in years 1 or 2. I want to be found incompetent, if at all, in years 8, 9, or 10. So I can have a lot more years of independence and control. Well, that disability panel is in Article 4. It sets forth what's required. So you're going to want to know that one. Article 4, Section 2 specifically. So you're going to want to go to that. The other thing in Article 4 that you're going to want to know about for mental disability are the special guidelines and instructions that the trust maker put up for the successor trustee to follow if we're in that long-term disability situation. So I don't know about you, But I've got a strong preference, in fact, all my clients do, once I bring them this scenario, that if I'm in that long-term mental disability situation where I have moments of lucidity, but I've also got to be watched over from time to time, I've got a strong preference that I want to stay in my own home as long as possible. I don't want you carting me off to the nearest nursing home at the first sign of trouble. And so bring in a nurse's aide, bring in someone to watch over me during those limited hours in which I am incompetent and I need to be watched over. But then the rest of the time, and do it in my own home where I'm comfortable, I know my surroundings. So those kind of instructions, including that one, are in Article 4, and that's an important one. So we have done that for our clients. When we started our planning, what we did is we gave them all some homework. And part of that homework was disability instructions. And they were literal check-the-box scenarios. So that first one, stay in my own home as long as possible, everybody checks that box. And so you want all those boxes checked, put into the trust. They are, and it's all located in Article 4. Also, the ability to amend or revoke the trust, Article 4. The ability to add or remove trust property, Article 4. So that's where those things are located. Article 5. This covers assets with beneficiary designations, like IRAs. There are certain rules that apply. We need those things in our trust to make sure trustees don't act in a way that causes our tax-deferred status to get blown up. And we have to pay a lot of taxes. So we've got to follow some rules on that. And those special rules of retirement plans, Article 5. Article 6, I talked to you about that temporary holding place container called an administrative trust. You're going to find the provisions for setting that up in Article 6. It talks about there in Article 6 that you need to get a taxpayer ID number from the IRS, that EIN number I talked about. Remember, when somebody dies, their Social Security number dies with them, we now need a new number. That's what we need to get. It gives the trustee the authority to pay claims and expenses out of the trust money for and on behalf of the trust. It allows us to apportion the apportion the assets so that we are paying all the debts and expenses of the trust or the estate first out of the big pot of money of the decedents and then distributing it to the beneficiaries, as opposed to just dividing all of it to the beneficiaries and then each beneficiary having to pay their pro rata share of the expenses of the estate. We want the beneficiaries, when they get their money, to know that that's all their money. They don't have to worry about spending it on behalf of the trust. Article 7 is dealing with specific bequests. Specific bequests is where we take tangible personal property and we can take certain items right off the top and give it to a particular person, right? We can do that in two ways. We can do that informally through a memorandum. Memorandum that just describes the item of property and who gets it. We sign and date it. And in Virginia, you can do that on any type of paper, no particular format. It could be on a napkin, it could be on a scrap paper, as long as they know it's yours, handwriting, and this was a person. So I could have, you know, a picture of Don Quixote, you know, charging a windmill. I love Man of La Mancha and Don Quixote. And so I could say I want that picture to go to the little boy down the street who also likes Don Quixote. I would describe that picture and the boy's name. I would sign and date it. And what we've done is we've referenced the use of a memorandum in Article 7, which means it incorporates that separate document into our trust. So it's legally binding. So this is what helps us take certain items of tangible personal property and give it to certain people right off the top. The second thing it does is, with the specific bequests, it can give larger items of personal property. I could give my car to my youngest daughter, or I could give my car to my nephew, or the grandfather clock to the niece, or something like that. Something that's going to go right off the top before anybody else gets it. And then my general distribution, which is located somewhere else in the trust, takes care of itself later, right? These are specific bequests. They're all contained in Article 7. Article 8, Article 9, Article 10, we'll cover real quickly. This is only applicable on the married side, where it's creating a marital and family irrevocable trust, those sub-trusts we talked about. And these are the provisions for the marital trust, the family trust, and these are only in the married client trusts. Then we have a common trust. The common trust is going to be in different places depending on whether we are single or married, right? So if we're married, it has to come after all those other articles I just mentioned. So it's going to be in Article 11. If we're single, we didn't have all those other articles I just mentioned, it's going to be in Article 8, right? So what's its purpose? Its purpose is to create, if we want to, a distribution scheme similar to what I call a big, giant soup pot. A pot of soup, a pot of chili. When I was a kid growing up, I was an only child. And so I'm used to the little saucepans that my mom used to cook, right? But my best friend was one of 8 children. And whenever I went and stayed the night with him, which was quite frequently because my mom was in bad health and was in the hospital for many days in a row. So I spent a lot of meals with them. And with a family of 10, 8 kids, when they served a meal, I mean, they had these huge pots. I mean, I'd never seen pots this big before. And they'd use these ladles. And they'd start with the smallest child, and they'd ladle it out, and then they'd go to the biggest child. Well, the smallest child, who was 3 at the time, they're not going to eat as much as the teenagers, the bigger children, right? So the idea of a soup pot trust, or a common trust, is we ladle out the assets that we have to our children or our beneficiaries based on their needs, not equal. And so that's where this would happen. A lot of my clients, though, don't like that concept. So if they don't like that concept, we don't use the common trust. And so what we do is it often says, it is not my desire to create a common trust for the benefit of my children. So that may be the Article 8 or Article 11 common trust provisions you see. And that's why. Article 9 for the single. Now you see we're diversing. We bifurcated this now. So now the trust is a little bit different. For single, it's Article 9. For the joint or the married, it's Article 12. And this is the main distribution pattern. This is where everything that was not given out in Article 7 with specific requests or a personal memorandum, that's where this is going to go. And typically, if it's a married situation with children, it's going to say something like, on the second of us to die. Meaning, it all goes to the spouse, surviving spouse first, and then on the second of them to die, Article 12 kicks in and says all to the children, right? Evenly. That's the typical scenario. It could say whatever it is. I mean, it could be nieces, nephews, 10% to Joe, 15% to Aunt Gladys. It could be anything here. But that's where it's going to be. Article 12, the general distribution scenario. It also has specifics in here about what happens if, I've predeceased. I'm a child of yours. I predeceased. What happens to my share? Often it will go to any children I might have equally. And if none, then to my brothers and sisters if I had any, right? So we've got all those provisions in Article 12 if it's a joint marriage situation, or Article 9 if it's single. All right? Then what we do in Article 10 for single, Article 13 for the married situation, is have another article. This is really not likely to happen. I call this the nuclear bomb scenario. This is where everybody in Article 12 has predeceased. So the nuclear bomb scenario in my stories, we all have the family reunion. Now you can imagine, being an only child, the idea of a family reunion is foreign to me, but it's a very positive fantasy of mine to have a situation where you have all these brothers and sisters and the family, aunts and uncles are coming in for a family reunion. You're in the picnic tables thing and you're all sharing and laughing, having a good time and seeing the family, right? The bomb goes off, the nuclear bomb. So everybody that was in my plan, my estate plan, goes kaput. They're gone, right? Now what happens to my estate plan? We need to have something there. This is really the backup plan to the backup plan to the backup plan. Not likely to happen. So I always tell my clients, we need a plan, but don't spend a whole lot of time stressing and fretting over what this plan is going to be, especially with the maintenance plan where we can kind of tweak this and reassess it every 2 years. So, but we do need something in place. So it could be maybe a charity, maybe my high school, maybe my college gets it, or maybe my college gets some of it, my high school gets some of it, my charity gets some of it. Maybe I have several charities. Maybe I have a niece or nephew, uncle, a friend can share with this. So it can be all sorts of things, but it's going to be something or someone who is not in my general distribution pattern. That's the nuclear bomb scenario, and that's going to be in Article 10 for a single trust, Article 13 for a married trust. It's the final distribution pattern. All right, unanticipated beneficiaries. We've got a plan for those too. So what happens if we have a situation where we have maybe someone who was healthy when we named them, they now are unhealthy, maybe they are brain damaged or something like that, they need to be watched over, something like that. So maybe now we have a special situation. It's an unanticipated situation that involves one of our beneficiaries, often mentally or something like that. So Article 11 in the single trust, Article 14 for the married trust, provides a couple things. First, we want to set it up so we have a trustee in place for that so that there's no court supervision. We want trustees to have discretion for special needs, things like that that they might need to set up. And so that's all going to be in that article. Trustee resignation, trustee removal, trustee succession. We need a plan for that. Things change. People we trusted today may not be trustworthy tomorrow. All sorts of things can happen. Maybe our favorite, most trustworthy trustee, successor trustee, used to live right next door to us. They would have been great, but now they live in Tahiti. They moved. They're not going to be so great, even though we trust them. So we might need to change, remove a trustee, things like that. There's all sorts of contingencies we need to provide for. Those contingencies are provided in Article 12 for the single, Article 15 for the married, and then the disability and death trustees, we separate out because they could be different people. You could wear two hats. I could be a mental disability trustee helping you as you're still alive to pay the bills, but then when you die you want someone else to handle things. Or I could be doing both. So we have it separated out, and that those people are designated with successors to each of them in those articles, 12 for the single, 15 for the married. There's going to be some general provisions that we need in every trust to account for certain things. So this is kind of, again, what some people think is boilerplate, but it's necessary. Again, we don't know whether we're going to need some of this stuff. Some of this stuff was going to apply in a lot of situations or all the situations. This is the place we put them. So in Article 13, if it's a single trust, Article 16, if it's a married trust, things like we don't want a bond to be required. We don't want the trustee to have to get a bond. We appointed the trustee because we trust them in the first place, right? A bond is used to protect the assets in case we have a rogue trustee. Well, we don't anticipate that. So absent something like that happening, we waive the bond requirement. No court supervision required. We set that out. We don't want the court involved if it's not necessary. We want this to be able to be taken care of privately in the comfort of our own living room or dining room table or whatever. And then provides things like a trustee. They are entitled to a fee for their work. Typically, if it's a family member and it's not too much, they won't take a fee. But if they're the only family member handling everything and there's some work to be done, then they're entitled to a fee, and that should come out of the estate before the distribution is made. Certainly if they're not a family member, that trustee is going to charge a fee. There's a lot of work to be done. Trustee powers. Okay, we've named a trustee to succeed us if we become mentally incapacitated or we pass away. Now we need to make sure we have provisions to let them know what their authority is, what their limits are, that type of thing. Those powers, those trustee powers, are located in Article 14 of the Single Trust, Article 17 of the Married Trust. It sets forth definitions. Article 15 of the Single, Article 18 of the Married, and it has what we call the school bus provision. That's that asset protection story I told. I don't use the school bus story because it's so unusual to, have our loved one hit the school bus. I told the story of my wife hitting a car, right, and killing the family by accident. They were speeding, going too fast. But in the school bus story, she doesn't hit a car, she hits a school bus full of children, and several children are killed. That's catastrophic. The point being that asset protection. Well, that asset protection clause is in Article 15. There's a clause and provisions, it's a contract throughout this trust. All right, that's the main part of covering the various articles. I encourage you, either as one of our clients who has your red book, or as a family member who doesn't have the red book, to maybe go over it together in the red book and watch this video, this class, and kind of go through these provisions, these articles, so you can see what I'm talking about in real time. I think that might help. But in the meantime, now I want to talk about is a couple specific provisions. First, we need something to help us with what I call the hit parade. The hit parade is our kids having something happen to them in the future. They could hit that school bus. They could be hit by the school bus. They could hit the bottle. They could hit the gambling table. Doesn't have to be bad. They could hit the lottery. There's a lot of things in life in the hit parade that really change the dynamic of our estate plan, potentially. In order to be able to make changes to compensate or to address those changes that might occur after we have become mentally incapacitated, the trust maker, or died, we need to have a tool to do that. And that tool is called a power of appointment. That enables us to make changes to the trust terms on behalf of the decedent, or it could even be used on behalf of someone who's mentally incapacitated. So we're walking through that, okay? There's two types of powers of appointment. One is general. It's more broad. It causes property to be subject, to be included in the holder of the power, their gross estate. So, for estate tax purposes. So if we give our child a general power of appointment in our trust, by virtue of that child having that power, all the trust assets of the parent for estate tax purposes are included in their assets. This can be rather dangerous because, let's say I've got, let's be positive, let's live for the fantasy of this. Let's say I've got $5 million. I don't have $5 million. I can hope I have $5 million. Let's say I have $5 million of my own money and assets. My father, let's say, had $10 million of assets. Okay, that's a pretty good deal, right? And I'm the only surviving child, So if I have a general power of appointment over all of my father's assets, then not only is my estate going to be seen to hold $5 million, it's going to be seen to hold an additional $10 million. I have an estate of $15 million. And I'm going to be paying an estate tax unless the law by then has changed to give me a personal exemption beyond that amount, or no estate tax. So there are some repercussions that we need to be careful about, because there's inclusion. It's called inclusion. I get all their assets counted against me in my estate as well, if I have a general power of appointment. So a lot of times we don't want that much power. So what we have is a limited power of appointment, which, as by its definition, is limited in that, and doesn't cause inclusion of that person's estate assets into our assets. That's the value and advantage of that. But it also allows us to make some tweaks to the plan, to address the hit parade, to address things like, okay, beneficiary number one hit the gambling table. So I'm going to change the trust to say, okay, beneficiary number one still is entitled to be a beneficiary. They're still entitled to get the same amount of money, but before we give them the money, we're going to require them to have a special term and condition of successfully completing a Gamblers Anonymous class, or a financial management class, or something like that. So we can make those kind of changes with a limited power of appointment. Again, to address the future that we don't know. It gives us flexibility. That's the whole point. Now there's another way of protecting against the future, and that's by using the ability to make changes in our trust to protect against the future, and that's using a trust protector. This is getting to be pretty common. It's been common in our trust for years, but now the rest of the industry is making it pretty common as well. You'll still see a lot of trusts where we don't have trust protectors. All of our trusts and all of our clients have a trust protector in their trusts. It's going to be located in Article 16 of the married trust, Article 13 of the single trust. And what this is an independent person, typically the lawyer, typically us, which the trustees or beneficiaries can name if they need to make changes. So with our situation, typically this comes up where, let's say they passed away, but they've got those irrevocable trusts now in place, right? Or a situation where they just need to keep up with the trust, they become mentally incapacitated. We can continue to make changes to their trust. We just can't make their own personal changes. They can't tell us what changes they want. But we can keep it updated for saving taxes or anything that's consistent with their intent, which is documented by a memo of intent, preferably. We want it documented. And so we can carry forth the trust maker's intent. They would have made those changes if they could have, but they can't for various reasons. They're incapacitated or dead. And so the trust protector makes those changes and puts those things in place to alter the document and allow it to be a flexible document that way. All right? All right, so that's trust protectors in a nutshell. So overall, when we talk about the red binder, find the red binder if something happens. This is a red binder. Every client has one. Most married couples have their own. There are some married couples who have a joint one, but most have their own. Either way, this is what we're talking about. It's got everything in it, not just the trust, powers of attorney. It's got the medical power of attorney. It's got the living will. You name it, it's got it in there. So highlighting Article 4 is your guidance for mental disability. Article 7, your guidance for specific distributions of certain tangible items of property. Article 9 or 12 is your guidance for the general distribution of the trust, of all the assets. Article 12 or 15 is where you go to find who the disability trustees are, who the death trustees are. Those are the main highlights of that big long document. Each of those trusts, though, have a very detailed table of contents, so you can find other things in there. You can certainly call us or email us. If you can't find a certain provision, we'll help you find it. But the whole point is, we want you to have a good warm fuzzy as to what is in these trusts. Remember, the whole point of this class is our frustration at seeing so many people with trusts. They come in, they've had these wonderful trusts made for them. They put them on the shelf. Those trusts have done nothing but collect dust for years. And when you ask simple questions, is your trust revocable or irrevocable? They don't know. Does it provide for an outright distribution, or does it stay in trust for asset protection? They don't know. Does it have a trust protector? They don't know. Does it have a power of appointment? And if so, is it general or limited? They don't know. We want our clients and our families of the clients to have at least a warm fuzzy as to what's in these documents, how they work, the concept behind them, so that you're not intimidated by the process, you're not intimidated by the idea, and it gives you that peace of mind that we're always after in our estate planning. So with that, I'm going to wrap this up. Hopefully this will give you a good sense and confidence of the process of a trust and how it works. And again, at any time, feel free to rewatch these videos. Nuts and Bolts 1, remember, Successor Trustee Training. This is Nuts and Bolt 2, Understanding Your Trust. And you can go back to these at any time and refresh your memory and get that new education. So thanks so much for listening. Thanks for your attention.